stuck between my rights and my wrongs. Second guessing what I'm doing. Like, am I really there for my boy? Not enough, but if I'm paying child support, do the making for time that I've lost. Whole time paying this court system. Can't even call my little man a game system, cause my checks be short. And if your bag too short, well, you had to miss a month. Slipping up, I gotta pick it up. Grind limitless, but it got your folks like, yeah, I hope you don't get caught. Like I missed them payments on purpose. Cause you see I failed and I'm hurting. Ain't had no job, so no working. Or the job I work is not working.
Shalom, this is your Ark. Yah is magnified. Coming back with another informative video. I titled this video, Will Gary Lynn Scott Jr. have a trial before a federal court? But before I tackle this subject, as always, I must state for the record, I'm not a lawyer, I do not practice law, and I do not pretend to. All my videos are for informational and educational purposes only. They're all facts and all truth. Nothing more, nothing less. So with that being said, let's get to it. Okay, guys, this is part 3 of a 4-part video series. So guess what? If this part 3, that means what? That means we're getting down to the wire, okay? We're getting down to the nitty-gritty. The last video we went over was what? It was the defendant's motion for what? Summary judgment, okay? The defendant filed 2 motions for summary judgments. One of them was 16 pages. The other one was 22 pages, okay? All 16 and 22 pages was filled with case law and statutes and codes to support the fact that Gary Lynn Scott Jr. do, in fact, have a legal duty to support his offspring, a.k.a. child, because it's the same thing, okay? There's no difference. So now, we're going to go over the fraud of law's client, Mr. Armando Rivers, who been making brothers sick, you know, for years now, for 30 years straight, by not showing any, or by not providing any remedy to their situation. So these brothers are sick, man, I'm trying to tell you. So now, we're going to go over this. We're going to go over his client's response to this motion for summary judgment. We're going to see if the fraud of law really do know how to respond back. We're going to see if he has 4D skills. Let's see if he's capable of keeping up with these attorneys out here, you know, who's dropping these case laws, statutes and codes and everything else to support their argument, which is prima facie evidence, supporting the prima facie evidence, stating that Gary Lynn Scott Jr. is, in fact, the legal father with the legal duty to support his offspring, aka child. Okay, so now this picture's up at the top. As we all can see, this is coming from where? In the United States District Court for the Eastern District of Tennessee. Everything is still the same as before. Gary Lynn Jr. of the family Scott, the party aggrieved, versus the 42 U.S.C. 654-3, a lone, separate, and apart child support program, right? This was filed when? Filed on February 7th, 2020. Last month, this year. Okay, as you all can see. Let me zoom out. So now let me stroll up. As you all can see, or should I say stroll down. As you all can see, that's the case number. You all get time, type the case number and do your own research. As we all can see, this is the what? Response to defendant's motion for summary judgment of Hamilton County, Tennessee, and Larry Henry. Let's read it at the top. In opposition to defendant's motion for summary judgment, pursuant to Federal Rules of Civil Procedures 56, Hamilton County, Tennessee, Hamilton County, or the county, and Larry Henry, Mr. Henry, the plaintiff states that the motion should be denied and the trial by jury should be pursued in the best interest of the public. The plaintiff responds with the following. 1. The defendant, Larry Henry, and Hamilton County, along with all other defendants, continues till this day to deprive me of my rights, privileges, and immunities secured by the Constitution and laws of the United States of America. He deprived me and continues to deprive me by participating in Hamilton County's Title 4D program, which is responsible for violating my rights to due process and taking my property, okay? Let's read number 2. 2. In the defendant's introduction on page 1 of 22, docket 75, it stated that the plaintiff attempts to transform the consequences of marriage, procreation, divorce, and the subsequent assessment of Title 4D into constitutional violations. That's true. That's exactly what the fraud of law do. He's in there arguing domestic relations situations in federal court, trying to make it seem as though it's a violation of a constitutional right, which then get thrown out. Why? Because federal courts cannot hear domestic relations issues anyways. The court lacks subject matter jurisdiction. But let's continue. Plaintiff responds by declaring that the defendants violated his constitutional rights to due process by not complying with 42 U.S.C. 666 AC1, was violated when the defendant violated his own oath of office by denying the plaintiff his right to be aware of the consequences before signing an acknowledgement of paternity. Okay? But he's trying to use the fact that he signed an acknowledgement of paternity, and he's trying to go against that, not having any understanding of what he's talking about. Why? Because if you signed an acknowledgement of paternity or not, you was what? You was married. Okay? Because it came from a consequence of marriage. So because you was married, you are automatically considered to be the legal father. And if you're automatically, considered to be the legal father through the marriage certificate, then guess what? You automatically is stuck with the legal duty to support the child. And it's just that simple. But let's continue. Let's continue with the rest of the argument. C. Voluntary paternity acknowledgement. 1. Simple civil process. Procedures for a simple civil process for voluntary acknowledgement of paternity, under which the state must provide that before a mother and a putative father can sign an acknowledgement of paternity, the mother and the putative father must be given notice orally or through use of video or audio equipment and in writing of the alternative to, the legal consequences of, and the rights, including, if one parent is a minor, any rights afforded due to minority status and responsibilities that arises from signing the acknowledgement of paternity. Okay, but again, what he failed to understand is this: he was married, and once you are married, you're automatically the legal father. You don't even have to sign an acknowledgement of paternity or anything. You are the legal father, and it's just that simple. But let's continue. The defendant, Larry Henry, and Hamilton County participated in taking of the plaintiff hard-earned property in the form of Federal Reserve notes, money. For one, Federal Reserve notes is not your property. Okay? Federal Reserve notes is property of the Federal Reserve Bank. But let's continue. 3. The plaintiff claims are that he was never given any notice, orally or through use of video or audio equipment, nor in writing, of the alternatives to, the legal consequences of, and the rights and responsibilities of signing the acknowledgement of paternity. So it appears that this whole argument now is about him signing the acknowledgement of paternity. But let's continue. 4. Plaintiff claims are that 45 CFR subsection 301.101C2 C safeguards under expedited process. 2. Let's read number 2. 2. The due process rights of the parties involved must be protected. Defendants Larry Henry and Hamilton County, along with all other defendants, violated Scott's rights to due process by not informing the him property as stated in 42 U.S.C. 666A 5C1, which again states, excuse me, guys, and that's still all the same. We just read that. Let's continue. The plaintiff was never informed of any legal consequences, never was given any audio, video, or in writing of these legal consequences. So therefore, Larry Henry violated my due process rights. Number 5, the plaintiff claims that Larry Henry and Hamilton County violated Scott's rights to due process when he violated the Omnibus Budget Reconciliation Act. Okay, he quoted the act. You all can pause that and read that. Then it states, the plaintiff affirms that the birth certificate, the voluntary acknowledgement of paternities that were signed, and the birth of his offspring never was accompanied with video, audio, nor in writing of the consequences of signing. 6. Below is evidence of the State of Tennessee website. And let's read it. Let's go over the rest of it, okay? Zoom out. And this is what he used as evidence. Come on, man. This was his argument. 2 pages of him complaining about the voluntary acknowledgement of paternity and he's married, was automatically gave him the legal duty to support the child. And this is his argument. This what the fraud of law gave him to file into federal court. As this going to be a defense? Come on, man. Cut it out, man. Cut it out, man. This case is over with, guys. I hate to bring you the news before it starts, but this case is over with, man. Gary Lynn Scott, be prepared for the motion for summary judgment to be granted, man, because you don't have a clue of what you're doing. And the person who's helping you don't have a clue of what they're doing. And it's just that simple, man. So, again, guys, stay out of these federal courts. I will be back with part 4 to further prove that the summary judgment was granted and it haven't been granted as of yet. So, and the day is what? March the 20th. So, it haven't been granted yet. I will bring y'all the summary judgment motion once it's granted. and show you all that everything I'm telling y'all is true, okay? Again, man, again, study to show thyself to prove. If you all need my help, hit me up in my email at yardismagnified@gmail.com. Let's continue to apply this pressure. Let's get this right wisdom, this right knowledge, this right understanding. So with that being said, I say shalom.